All right, everyone, welcome. It's wonderful to see all of you, and welcome to the Transnational Law Institute lecture. I'm absolutely honored, as we all are, to have with us here Lucy Reed, the president of the American Society of International Law, a distinguished international arbitrator and lawyer with both a dynamic as well as a diverse practice. In addition, Lucy is a brilliant example of professionalism, with her unstinting and enthusiastic commitment to public service, mentorship, and not just the practice of law, but the rule of law. The Transnational Law Institute itself is a collective whose programs, whether they be our speaker series, our internships, our curricular reforms, our visiting scholars, and sundry other activities, would not be possible without the fantastic law faculty that we have, both generally and also, I'm partial, in the international law area, without the support of our dean's office and the critical support of administrators such as Florentina Butler and Diane Cochran. Diane, in particular, is an exceptional organizer and is really the center of our work, and without her, there'd be neither an institute nor any functionality. I now turn to my wonderful colleague, Rick Kurgis, who is the standard bearer of international law here at Washington and Lee, to introduce our honorific speaker.
It really is a privilege to introduce Lucy Reed to you. It's a personal privilege. I've known her for a few years now, and I stand in awe of her accomplishments, her work ethic, and all that she has done. If I tried to run through her whole resume, she'd have no time to give her lecture. So I'm going to be very brief and just summarize some of the high points. As Mark mentioned, she is the president of the American Society of International Law. She is also a senior partner in the prominent multinational law firm of Freshfields Bruckhaus Deringer. And she's in the New York office, but it is a worldwide law firm. She has been a lecturer at the prestigious Hague Academy of International Law. She's a former U.S. agent representing the United States and the State Department before the Iran-U.S. Claims Tribunal in The Hague, and she held other positions in the legal advisor's office of the State Department. She's an experienced international arbitrator, and in other cases she has represented clients in arbitration. So she's seen international arbitration from virtually all sides that you could see it from. She has published books and articles on international arbitration. She knows her stuff. Not only all of that, she's a delightful person, and she's a great lecturer. She's going to talk to us today on International Claims Tribunal with a focus on victims. Let's welcome Lucy Reed.
Thank you, Rick and Mark. That was very generous. Right now, I'm actually spending most of my time preparing for a very difficult arbitration hearing for a very difficult client. So this is a wonderful escape to be talking about ideas with you all. Thank you very much for inviting me, Professors Kurgis and Grumwall, and also my close colleagues, Professors Frank and Osofsky. And I must say I've gotten one of the most warm welcomes here that I've ever received, for which I thank Dean Smola, Associate Dean Danforth, who's here, I know, Professor Brunner, who shared dinner with me last night, Sarah Melke, and other students in the International Law Society who shared breakfast with me this morning, and Diane Cochran, who arranged everything. So thank you all. I'm here primarily as Professor Kurgis said, as president of the American Society of International Law. So I'll do that bit first. The ASIL is the leading society of international lawyers in the world. It's 104 years old now, and I would be really remiss not to mention how active your professors are in the American Society. After first mentioning that Washington and Lee is a very valued academic partner, which requires a generous contribution to the American society in exchange for services we hope we provide. Washington and Lee has been in there since the beginning. Professor Kyrgyz is our secretary and historian. Wrote for our centennial a very thick brick of the history of the society, which I carry around with me usually, but not this time because I knew I could borrow it. My husband has said, would you please get that off the bed for a change. Professor Grumble I've asked to be on the awards committee this year, and of course he's received a book award himself. Professor Frank, I asked to be on our honors committee, and Professor Osofsky is here somewhere probably, there you are, is one of the 3 co-chairs of our annual meeting, which is the single biggest meeting of international lawyers in the world each spring. Always well over 1,000 people come. It's a huge task. And it's not only great that Washington and Lee has so much participation, it reflects how often I call upon your professors and what a reputation they have in the broader world and what good scholars and people they are. So you're very fortunate to have the Institute and to have this faculty. Now, I would be even more remiss while I have all you students captive here not to encourage you, as I did at breakfast, to join the society. I sound like food shopping network or something. It's only $35, which is not that many lattes, right? And I have some applications right here, but seriously, for student members, you get quite a bit. Most important, publications. The American Journal of International Law, which is the leading journal. Even I can't get through many of the articles, which I should admit, but many are very, very interesting and topical to what you're studying. But we also sponsor the Helton Fellowships, which are fellowships to give extra money to human rights, to students or young lawyers who are pursuing human rights projects around the world but don't have quite enough money to do it. So those are available. There's great opportunity for networking, not just at the annual meeting, the theme of which this year is International Law in a Time of Change. You are change. You should consider getting up to Washington for it. But we have website material on career opportunities, bulletin boards of available internships, fellowships. We have many seminars on career advice and books on career advice in international law. And the last reason is the one I've shared with Rick before, is just because. You should be a member just because if you are interested in international law, you should join the tribe of international lawyers in order to be versed, and joining the society is one way to do it. I can't stand here today or anytime and tell you how to get through to a successful career, an end goal in international law, whether it's criminal, prosecution, or something else. But I can tell you how to start. And one way to start that is to get involved with other young scholars and practitioners of international law through the society. So now let me move on here. I want to start, as requested, with a little bit of career advice, a little bit, and biographical information before I go to my topic. And I would say to start, I have had simply the good luck and privilege to practice in international dispute resolution, which is a field with a lot of innovation in my lifetime. There's an old saying that litigation is the last refuge of the generalist, and international commercial arbitration is really, I think, the last refuge of the generalist, because we're dealing in public and private international law in all sorts of sectors and industries and people as well as countries. It's not a large practice area, but it's a particularly interesting one for someone of my interests. In international dispute resolution, there is a spectrum. There is, on the one hand, the more normal international court, international tribunal, arbitration, civil liability institutions that resolve commercial disputes or treaty disputes, final and binding nature. It's all civil and formal, recognizable to you from a U.S. perspective. At the other end of the spectrum are the international criminal tribunals, which focus, of course, on personal criminal liability of defendants. Unfortunately, that is a prominent and growing area of international law right now. There was Nuremberg, And then there's this whole new group of international tribunals for the atrocities that we have been witnessing. I'm not going to really address either of those today. I'm focusing on a hybrid area in the middle of that continuum, which we call international claims tribunals or international claims commissions. It's not very well known, hence something I like to inform people about, because some of the topics are very interesting, and I've, again, had the good luck to work with several as an advocate, as a government agent, as a director, and as an arbitrator. How and why did I get that opportunity? Well, I used the word luck on purpose. As I've told other people this morning, I am where I am because of the Islamic Revolution of 1979. It was a result of that big political tsunami that in my first law firm, after a clerkship, I represented several U.S. corporate claimants in front of the newly created U.S.-Iran Claims Tribunal set up in The Hague. This is ancient history to you all, but the U.S. hostages had been taken in our embassy in Iran, and part of getting them released was unfreezing money that had been frozen, Iranian money in the United States, giving most of it back to Iran, saving $1 billion to pay claims, and then setting up a substitute tribunal for U.S. companies and U.S. individuals who had lost everything in Iran when they had to flee. That tribunal is still in existence for various reasons, but in the 80s it was very active. And I really cut my teeth in international arbitration doing those cases. And then I was invited by the State Department to go and help prosecute their claims in the Iran Tribunal. And ultimately, as you heard, became the U.S. attorney there. All very, very interesting. I did other things at State as well. Many of us who were in our 20s at the time of the Iran Tribunal are now, for better or worse, recognized leaders in the field of international arbitration, because that was what was active when we were young lawyers. We had, again, a tribe of veterans of the tribunal. And I mention this for two reasons. For this audience. The first is that your opportunities, I can promise you, will be different than my opportunities at age 25 or whatever. And all I can say to students is to be open to what develops in the first few years and the middle part of your career. As I've said to Professor Frank, don't be afraid to take interesting jobs that pay ever less money if you want to do very interesting international work. The second point here is that if you pursue a career in international law, don't expect constant thrills. It's not that glamorous, really. As international law, particularly dispute resolution, expands into new areas, yes, certainly we're developing new substantive law, and we're seeing customary international law develop and writing new treaties. It can be exciting, and sometimes it's even heady. But it goes hand in hand with, or really it's eclipsed on most days, by the basic building blocks of procedural skills and functional skills, as is any lawyering or teaching in law. It's tedious document review, but you win cases with your documents. It's careful drafting. It's practicing your advocacy. It's those building blocks. I've said to students last night, and I said to students this morning, if you want to know, in my opinion, what to take if you want to end up doing the kind of work I do, it includes taking civil procedure, evidence, criminal law, corporations, securities, accounting, all of those things, as well as international law. And I like to see curricula like you have here, where international law topics or skills are embedded into contracts and torts and other basic topics. And I was, again, lucky to be able to give Hague lectures in private international law back in 2001, and I had the very grandiose title of Mixed Private and Public International Law Solutions to International Crises. Very, very grand. But this quote is the heart of what my lectures were. I had been talking about how the European Union started as a steel collective, which a lot of people don't remember, and said that the heart of what we do here is roofs, hearths, coal, steel, etc., claims forms, computer programs, unglamorous, untheoretical things that comprise the currency that are in demand to solve real international crises, not just diplomats running around the globe. So with that unsolicited career advice behind me, so you don't have to ask me afterwards, I will talk about several claims commissions that deal either with commercial disputes or post-war victims' claims, and briefly compare them with the international criminal tribunals, always with an eye on the victims. Why? Because these institutions are victim-driven. They are not about opportunities to lawyer. They are not about opportunities to judge. They are about opportunities to provide compensation to large groups, small, medium, but mostly large groups of victims in the international world. Some of these claims tribunals are well known. Some are not. They vary greatly. I have to say at the beginning, sometimes I forget to say the very basic thing that while they can be big, they can be small, they can last for 20 years, they can last for 20 months. Generally, these are courts with judges who are appointed by the participating governments, sometimes by international organizations. Sometimes they have buildings, sometimes they borrow buildings, sometimes they have their own registrars and secretariats and libraries, sometimes they borrow them, for example, using the Permanent Court of Arbitration facilities in the Peace Palace in The Hague. Judges have diplomatic immunity, generally. Sometimes they're full-time, sometimes they're part-time. Often, and take a note of this, often they have, not only have, they depend on interns and legal clerks for the judges and for the registries to keep these institutions going, and it's a great source of creative work opportunity for law students. And I'll be mentioning, I'll take a drink of water while you read the ones that I would be mentioning today, because they're ones with which I'm familiar. Not the most important, they're just the ones that I know best. There are dozens more, and I cannot recommend enough, if you're interested at all in this area, particularly from a job standpoint, to go to the website of the NYU Law School project on international courts and tribunals. They have all the news of what's going on in the tribunals, and they also will post job opportunities. I'm not going to talk about each tribunal, but some common themes. I want to say first, though, that what interested me in preparing this talk, not this talk, but the concept for this talk in general, was attending the second Chautauqua Conference of International Criminal Prosecutors in the autumn of 2008, a year ago. I've just come back from the third, actually, where all of the senior prosecutors from the International Criminal Tribunals are invited, basically, by the American Society and other institutes to have a retreat where they help each other. So last year, Mark Drummel gave a superb talk, but last year the occasion was Nuremberg, and all of the living Nuremberg prosecutors came and shared their experiences and their advice with the prosecutors for the Rwanda Tribunal, Yugoslav Tribunal, Cambodia, Sierra Leone, what am I forgetting, Lebanon, ICC, International Criminal Court, so all too many. Absolutely fascinating experience, and led me thinking about because I had to give a keynote last year, what are the differences between the international claims commissions and the international criminal tribunals. And I can boil it down to these 2 points. And I don't have a lot of slides, only 10, mostly for websites, but I did put this up. In the international claims side, we come at life from the opposite direction of criminal prosecutors. The primary goal, I'm simplifying, of course, the primary goal of prosecutors is to punish individual perpetrators of international crimes, whether it's genocide or crimes against humanity, etc. And what for? Ideally to deter future violations and ideally avoid future victimization. So it's just like any criminal law. There's punishment and there's deterrence in those tribunals. They're very slow. They're hugely expensive. They have large staffs. It takes years and years to investigate in the field and finish a trial, so they can only focus on the most important senior perpetrators, although there are thousands and thousands of junior level ones. Now, in international claims commissions, our goal is to compensate or otherwise relieve the suffering of victims of past international law violations. It can be criminal level or civil level, but we focus on getting funds and assets and lives back to the victims. It's the same goal, though, really, from two different ends. If you bring a criminal to justice, of course, it's also a tribute to their victim and does help restore dignity to the victims and allow closure in their lives. They don't get any money, they don't get any recognition as victims, but it is aimed, victim-aimed as well. Now, there are a couple of good websites, which if you are interested to jot down, if you want to read more about the Chautauqua Humanitarian Law Dialogues and the International Criminal Tribunal side of things. Again, they also post job opportunities for internships as well. Robert Jackson, of course, is the U.S. Supreme Court Justice who was the first prosecutor at Nuremberg. That seems like an odd day, doesn't it, when the President would send the Chief Justice of the Supreme Court to do an international law job. Justice Roberts, I guess, wouldn't be available, or any Chief Justice, Now, to position the international claims commissions on what we call the international legal plane, I only want to talk about three characteristics. That's those three. Fixed compensation categories, low standards of proof, horrifyingly low standards of proof, and mass processing techniques, all of which equal what we are unapologetically call rough justice in this field, very rough. First, fixed compensation categories. Now, I've told you these are always civil proceedings, and the claims commissions give remedies in the form of either monetary compensation or asset restitution. There is no punishment component. It doesn't matter who did it, really. What matters is that someone suffered. Typically, the claimants, or plaintiffs, if you want, the victims are represented sometimes by themselves, but usually in groups by their national governments, and they're grouped into broad classes, as in based on harm. Did they suffer death, other personal injury, loss of property, loss of dignity, sexual abuse as well, something like that. And then each member of each class will receive the same fixed amount of compensation, kind of like U.S. insurance programs. If I remember in kindergarten getting that brochure, if your leg gets cut off, your parents will get $100. If there's an eye, that'll be $20. And just, that was my realization. So it is compensating for some horrifying things. The amount, you will not be surprised, can be extremely small, given the small pots of money that are available after events that lead to these commissions. But let me be specific instead of general. The UN Compensation Commission, I doubt many of you have studied it yet, maybe you have. This was a commission that was set up by the United Nations after Iraq's unlawful invasion of Kuwait, the first Gulf War, back in the early 1990s. The UN found that Iraq had violated the UN Charter by illegally using force to invade and destroy much of Kuwait and the people who were living there, and the UN set up the Compensation Commission to identify and compensate victims. There were lots of categories, from the guest workers who had to flee to the government of Kuwait itself, which suffered billions of dollars worth of environmental damage because the Iraqi troops flared and destroyed every single oil well that they came across, still being cleaned up now. Let's look at some of the individual claimant categories. These are human beings, not governments or companies. We're not very creative in this field. We used category A to be those who were forced to flee Kuwait after the invasion, particularly guest workers. Category B, those who suffered serious personal injury or the death of a close family member. And C, individuals who had business losses of less than $100,000, lost a small business, lost some property, lost cars, whatever else. Those three categories received priority treatment at the UN Compensation Commission, and the successful claimants were paid $2,500. Now, this even with my kindergarten experience, this may seem an insultingly insufficient amount of money for someone who's lost a son or a daughter or a parent, or been, as often happened in that war, really quite horribly sexually abused. But given that in the UN Compensation Commission there were 2.6 million claims filed, 2.6 million, all but 7,000 of which were of human beings, individual victims, you will appreciate that only broad classifications and small amounts of money being paid quickly would equal what we would call rough justice. And at the end of the day, actually millions of these claimants, A, B, and C, were paid small amounts of money that added up to several $billions. You might be wondering, where did that come from? The funds came from the UN Oil for Food program, which for those of you who are familiar with that and the corruption that the UN has still been investigating is another story for another day. But the UN did allow Iraq to sell oil, and a tiny percentage, about 0.5% of the proceeds, were funded the pot to pay the people who got awards at the UN Compensation Commission. So for the small claimants, it worked very well. Now, this is a personal point, I am very proud of this aspect of the UN Compensation Commission. Because remember I said, working at the Iran Tribunal, there are veterans of the Iran Tribunal who have done other things in claims, including help set up the UNCC. And in our days in the Iran Tribunal, we at the State Department, Legal Advisor's Office, were charged with representing what we call the small Iranian claimants, and those were American nationals or companies with claims under $250,000. They didn't get to have their own lawyers and have separate claims. There were 3,000 of them, and we worked on those ourselves, and we tried very hard to get those cases decided first. But for reasons that are too political and procedural to go into, the fact is that the corporate claims were decided first at the Iran-U.S. Claims Tribunal, and we did a mass settlement of the small claims later, which means that those people who most needed money, the individual American former servicemen who had gone to work for Bell Helicopter but had to leave and left everything behind, the small business owners, they didn't get paid until the very end, whereas the corporations got paid early on. And we didn't think that that was how we wanted it to be done, and we were able to prevent that at the UNCC, which I consider a success. Now, not all claims tribunals award funds. Very interesting development in recent years has been 2 tribunals that award assets back to claimants. The first is, it's a mouthful, the Commission for Real Property Claims for Bosnia Herzegovina, which was set up under the Dayton Peace Agreement, which you'll remember was the brokered peace of the war in former Yugoslavia. This Property Claims Commission was set up specifically to identify and return homes, real property, to individuals who, because of the ethnic cleansing, had been forced to flee their own towns and their own homes and couldn't go back. Now remember my first slide? Post-conflict societies need homes. You need roofs put on buildings. You need schools. That's one of the first things. And in the whole Serbian-Croatian wars, many people were displaced and couldn't go back to their homes because squatters had come in who were Bosnians or Croats or Serbs. So this commission was given a big chunk of money, and they had a big secretariat, a short period of time, to decide these home claims, these real property claims. Some of it was done in a room like this, but often the arbitrators, in bulletproof vests actually, just went out in the field and were shown apartments and valued them, or shown houses and knew who used to own them and who wanted to own them. And just in the end, they decided 300,000 real property claims. They had hoped after Dayton to give money. They assumed they would just give money because they knew people couldn't go back. But because they had so little money, which is often the case, the commissioner started giving vouchers, saying, for example, here's a voucher for an apartment that I've observed that you used to have in town X that we think is worth, I don't know what the currency would be, but say $20,000. Here's a voucher saying, we recognize you owned it, it's been taken, a Bosnian's living in it, and you're served, whatever. Fantastically, in my opinion, a parallel real estate market has developed in the region where you can take, I don't mean to be pointing at you, you can take this voucher for $20,000 and use it to buy an apartment in an area where you now feel comfortable to live. They've become currency, which is, in my opinion, and when you have little money, this is fascinating development. There's a second tribunal still going on now in Kosovo, the Housing and Property Claims Commission, which is, I think it's thousands of claims. Also fascinating because in Kosovo, as in the former Yugoslavia, people don't have titles to their homes. It's not just a question that they fled without the title to their homes. They don't give title to property. If you want to prove title, you need the grandfather down the road to say, oh yes, he farmed or she farmed that little plot around the corner from the post office that was about as big as that table. You know, it's all oral tradition. So that commission has faced a lot of challenges, but they also have been very successful. It's very prosaic. You return homes, you help return dignity to victims or compensation for homes. Second, besides the first category, the second is a very low standard of proof. These are administrative proceedings. They're generally not lawyers. Generally, the arbitrators or the commissioners, with help of their staff, look at the written documents that there are and make decisions. This can work only because there's a relaxed standard of proof. To establish a particular claim or a category of claims, you need to do that because there are so many claims that are related to the same set of events, an ethnic cleansing campaign, all victims of an ethnic cleansing campaign. And there's usually a lack of what we would call normal evidence. Maybe there weren't land titles, or maybe land titles have had to be left behind, so you have to accept oral testimony. Or just on written claims forms, I lost this, I lost this, I lost this. Let me give you a concrete example again. In the UNCC, there was a presumption of an unlawful expulsion of a person. Unlawful expulsion is a violation of international law. You cannot expel someone from the territory of a state without reason, an enemy combatant or whatever. If you just throw someone over the border, that's a violation of international law unless you've followed a certain procedure. So there was a presumption of the international law violation of an expulsion for any Category A claimant. Remember, these are individuals who had to leave Iraq, who could come forward with a passport or some other travel document to show that he or she had been in Iraq before the invasion and was out of Iraq after the invasion. Automatic $2,500 with that standard of proof. In the Bosnia Herzegovina Real Property Commission, the standard of proof was such that the commissioners didn't require proof of ethnic cleansing or a link between ethnic cleansing and a property loss to win on a claim. There was a presumption that any displaced person from that conflict was displaced because of the war. Will some people fall into the classes who don't deserve because they were out of Iraq visiting their mother? Yes, but that's a necessary risk. Now there's another tribunal in which I was one of the directors called, again, a big mouthful, the Claims Resolution Tribunal for Dormant Swiss Bank Accounts in Switzerland, CRT we called it. This was a tribunal that was set up through the extraordinary efforts of Paul Volcker, who you've probably heard of, and the World Jewish Congress, and others, the Swiss banks also, to find and return funds that got stuck in Swiss bank accounts at the end of World War II without ever having been claimed. For the banking law fans amongst us, in the U.S. that would never happen because if bank account money isn't claimed, it escheats to the state or nationally, so bank accounts go away if you leave your money in them. In Switzerland, the money can never go to the state. It has to sit in the bank account forever. Now, the Swiss had said there were no dormant bank accounts from World War II. It had all been taken care of, and through the investigative efforts, a lot of which was sheer accounting drudgery, the Eminent Persons Commission found many Swiss bank accounts from that era still with funds in them. And CRT 1, phase 1, the one that I worked on, was the process by which heirs of owners of those accounts or their heirs, we tried to identify them and return the money through a public process on 5,000. We did 5,000 accounts first. The standard of proof there was, and I quote, plausibility in light of the circumstances that a claimant was entitled to a particular account. And the world community was not told how much money was in the account. They were just told the name of the prior owner. And there were some common names. So lots of people wrote in, filled out claims forms. That's my father, that's my father, that's my father. Standard was plausibility. Try that out, ladies and gentlemen, on your civil procedure or criminal law professors, where I hope they have taught you about beyond a reasonable doubt or clear and convincing evidence. But really, what else can we do for relatives of Holocaust victims who were the target victims of this tribunal, who obviously don't have death certificates from Auschwitz, and they don't have bank account passbooks that belong to the original owners of the accounts, which is what, by the way, most Swiss banks were requiring in the 1950s, 60s, and 70s. So, just for fun, I'll put up, because I like specifics, not generalities, this is the relevant standard of the rules of procedure of the CRT, where the arbitrators were part-time arbitrators. The young lawyers did most of the work, frankly. The sole arbitrators shall at all times bear in mind the difficulties of proving a claim after the destruction of the Second World War and the Holocaust in the long time that has lapsed. A finding of plausibility requires that all documents and other information have been submitted by the claimant that can reasonably be expected to be produced in view of the circumstances, skip down, and no reasonable basis exists to conclude that fraud or forgery affect the claim, and that other persons may have an identical or better claim. We actually, I have to move on, but we got all kinds of evidence from some passbooks, some family letters, things with addresses on them, oral history, report cards, and there was only one. I'm happy to report that I can't remember now. I think there were about maybe 30,000 claimants on the 5,000 accounts, most of which were we could go through them and figure out it was just a mistaken name, because they would say when their relative had been born, for example, and we knew when the birth date of the real owner. But there was only one instance of fraud, which is quite extraordinary, because usually these claims commissions, as in national life, can lead to people trying to get money for nothing. So that's the standard of proof. And the last point is mass processing techniques, my third characteristic. You need special methodologies to process hundreds, thousands, even in the UNCC case, millions of claims. We're not very creative, as I say. We call them mass claims techniques. Statistical sampling, modeling, computerized matching, standardized methods for verification and evaluation of claims. The UNCC pioneered the use of computerized entry of claims. Governments would collect claims. Say, the government of Pakistan, for concrete, collected claims forms from thousands of its nationals who had fled fled Kuwait, or lost business, and then they would fill out forms, put them on a computer disk, send them to the UNCC. The UNCC statisticians, computer experts, would categorize them and code them. Professor Frank's great field of competence, and the staff and the arbitrators together would then try to make awards after all that sifting. Let me give you a very simplified example so it's not so vague. Pakistan, or country X, because I don't know what happened with Pakistan. Country X submits business loss claims, that category C I mentioned, for 500 nationals. Each has filled out a claim form to which documents are attached, if there are any. The commission staff, not the arbitrators, usually the staff, individually scrutinize a statistically relevant sample of those 500 files for business losses from country X. Let's say, I have no idea, sorry, Professor Frank, let's say they say 10. They want to look at 10. They pull 10 randomly, they study them, and if only 40% of those claimants, 4 of the 10 claimants, meets the standard of proof, then each claimant in that whole group of 500 will get 40% of $2,500. Which, it's not that the 4 get $2,500 and the 6 don't, or the 4 don't and the 6 do, because you can't look at all 500 when there are 2.6 million claims. You use that process. And that, I hope your professors will be happier now, because despite the standard of proof, that puts a premium on the national government screening the claims, because they want 80% of the claims or 100% of the claims to be valid, and it also helps make sure that there isn't claim inflation. Not too many people are filing. So these are the techniques that make rough justice still justice. So if you look at it one way, the way I try to tell myself when I get frustrated with the process, criminal tribunals have to deal with, particularly international criminal tribunals, deal with vast quantities of evidence for one defendant. Years and years of work because of the very high standard of proof, as it should be, and the penalties that we're dealing with. Claims commissions have to manage with small, tiny amounts of evidence for vast quantities of people. For those of you who are here who are interested in computers and statistics and all sorts of processing ideas like that, there's quite a demand in the standing international tribunals for that skill, because if you can link the computer skills and processing skills with the law, it's very valuable indeed. Now I'll end this little bit by saying I fear I'm painting a rather bloodless picture of these claims commissions as sort of sterile buildings with computers putting things in, spitting things out, checks going out. That's not the case. It's not all process and no empathy. The staff and the judges read a lot of written testimony from victims. There's oral testimony of some in some of the tribunals. Certainly at the CRT, that was our experience. It's very, very, very moving situation. And I got many letters from people who, when we wrote them and said, that's not your relative whose account that is, letters coming particularly from Argentina and Israel saying, that doesn't matter, we're just so happy to have someone pay attention to us now and to have made the Swiss banks deal with the situation. It's just important for the memory of my relative, even though it's not the same person. This leads me to a brief word on the Eritrea-Ethiopia Claims Commission, the last commission I'm going to mention specifically, where I sit as one of 5 commissioners who were called there. This was the first international tribunal ever set up to decide civil liability for violations of the Geneva Conventions and international humanitarian law that were committed during the very, very destructive World War I era weaponry boundary war between the states of Eritrea and Ethiopia between 1998 and 2000, when Kofi Annan brokered a peace agreement. In the peace agreement, 2 commissions were set up, one to decide the boundary, one to deal with humanitarian law claims for civilian victims. These were the 2 issues that 2 countries couldn't agree before they finished their truce. I ask you to remember that for a minute. It's not a criminal tribunal, although usually war violations of horrible abuses are dealt with in a criminal tribunal. Eritrea and Ethiopia chose not to pursue a mass filing system like I've been describing to you, although they could have. Instead, they did what we call espousing their nationals' claims. So Eritrea put in a claim in its own name for its thousands of civilian victims, and the awards go to Eritrea or Ethiopia themselves. So it's not technically a mass claims tribunal, but we did have use of rough justice evidence, claims forms, and categories. The categories included prisoners of war, expellees. A lot of Eritreans lost their Ethiopian nationality and were thrown out of Ethiopia, and vice versa. National civilian victims of abuses that included rape, detention, and beatings. And as I say, we had a lot of witness statements. We bifurcated the process. We decided liability in three groups of claims first, found each side had violated international law, and then we did the damages. I'm probably way behind here. All our awards are public. This is also pretty new. You can read any of them. The liability awards are particularly interesting, I think. Really rough justice on damages. But as I say, we found each government liable for violations of jus in bello. I try not to use Latin, but jus in bello is international humanitarian law that applies during the war. So you're not supposed to shell civilian areas. You're not supposed to plant landmines in certain areas. That's jus in bello. We found there was mistreatment of prisoners of war, civilian detainees, hidden from the International Committee for the Red Cross, physical abuse, mental abuse, fortunately only occasional rape, forced labor, and massive property destruction. We also found, and this has been very controversial, that Eritrea violated the jus ad bellum in invading Ethiopia, meaning that Eritrea wrongfully used force in invading Ethiopia in violation of the UN Charter. Our final damages awards just came out a few weeks ago, but we're in a 60-day period for the parties to keep filing for corrections, so you'll appreciate I can't talk about details, but I think you may be interested to know, if you ever wonder what the cost on civilians is of warfare, that these are two of the poorest nations in the world. They each ask for billions and billions of dollars of compensation, including care and treatment for their civilian victims. Not for the cost of running the war, for the weapons and everything else, or the soldiers, just for the impact on civilians. In the end, we're a strictly legal commission. We had to apply the rules of evidence, our standards of proof, and we ended up awarding approximately $170 million to Ethiopia and approximately $160 million to Eritrea. Remembering what I said to you about these two commissions being carved out of the peace agreement because the parties couldn't settle, it's a very frustrating process. If you look at anything on this website, you'll see it's extremely rough justice. There were 5 of us, no staff, part-time help from one person at the Permanent Court of Arbitration. We weren't allowed to go to the countries. But very successful, and 2 measures of its success, I would say, are this. Those 2 governments, who were a huge loss of life in that war, stopped fighting in December 2000 and left resolution of these issues to the law, to a commission applying the law as best as could be done under the circumstances, and that's now 9 years of people not being killed, so that counts. And on the eve of our prisoner of war hearing, which was our first hearing, Ethiopia let free a very large group of prisoners of war who they kept incarcerated against international law. But it was the pressure of the hearing on treatment of prisoners of war that led to the release of those POWs. So that's another measure of success in this area. I have up here on this slide just a reference to the International Organization for Migration in Geneva, which administers other claims programs. They're a repository of knowledge. They've done World War II slave labor, they've done the Roma claims, insurance claims, and they're now working on second Iraq War claims, and they have a Palestinian claims program nascent as well. My very last topic is to pull things together by talking about a new development at the International Criminal Court. As I've said, criminal justice obviously has to be slow and careful if you want a fair conviction of a defendant, especially if a death penalty is being discussed. Whereas victims of mass crimes have to be compensated quickly with rough justice to get them back on their lives, get them back in the home, get them back on their feet. So typically in international criminal justice, what's the role of victims? Witnesses for the offenses. There's no, same in our system. In the U.S., victims don't get through the criminal system any payment for the effect of a rape or a robbery, whatever. But the International Criminal Court, unlike the other criminal tribunals now, has a parallel claims commission for victims. The drafters of the Rome Convention created this group called, or this entity called the Trust Fund for Victims, which is advocating for victims and assisting victims of genocide, war crimes, crimes against humanity. And under the regulations, it operates independently. It's got directors, including Bishop Tutu, and they're free. The trust fund is free to assist victims, even if the ICC decides not to prosecute, because the prosecutorial discretion does not necessarily match the victims. They have claims forms. They have mass claims procedures, like I've been describing. You can see them on the ICC website, and they do outreach. The first victims' participation process is in the ongoing trial of Thomas Lubanga. For those of you who follow this, Thomas Lubanga is the Congolese militia leader who has been indicted at the ICC for enlisting, conscripting, and using child soldiers in fighting to fight for his group, which is the UPC, the Union of Congolese Patriots. In the proceedings, there are 99, many people filed, but 99 victims were selected to represent the victims' groups. They had to show a link to the crimes of Lubanga, or the alleged crimes of Lubanga. They're represented by 7 lawyers. The lawyers are present in the courtroom throughout the case. The prosecution has now, I think has finished or is just finishing, it has finished its case against Lubanga. They can question every witness on behalf of their groups of victims and present their clients' views. This is the first. This is really quite, for better or worse, and there are people on both sides, it's revolutionary. So the idea is that some victims will be testifying as normal fact witnesses in the criminal proceedings, but others at some stage, and we don't know yet when, will testify just about what happened to them and the damages that they have suffered in hopes to be compensated from funds which will be deposited in the trust fund. It's an evolving process. I'm advising one group, so I can't go into too much detail. But there was a huge development, I think, this spring, huge development. During the prosecution case, as I've said, Lubanga is indicted only for use of child soldiers, not for sexual slavery or genocide or other things. That was a prosecutorial decision that is what the evidence would best support, I assume. After listening to months and months of testimony about what happened to child soldiers, the victims groups could no longer avoid how much testimony there had been about sexual slavery of girls, in some cases boys, and the cruel and unusual punishment aspect of that, how much rape, how much sexual abuse there went into this child soldier program. So the victims groups, the ombudsman, asked the trial court to force an indictment on rape and sexual slavery and sexual abuse. You can ask Catherine McKinnon about this more when she's here in a few weeks. On July 14th, the trial judges ruled it is possible to add new charges on fresh evidence in the middle of a case. Both the prosecution and the defense have sought leave to appeal this decision for reasons you can imagine. That's pending. If the decision is upheld by the appellate chamber, then that may well lead to requirement for reinvestigation and a delay in that proceeding, because that would, of course, change the prosecution and the defense case. But again, whether one agrees with it or not, thinks it's a good idea or not, this is revolutionary in recognizing the role of victims in international criminal law. It's a challenge, I think, to combine witness testimony and compensation, but it's a laudatory goal. I will say just this. I happen to believe that it's not an impossible dream that convicted war criminals who have stolen vast sums of their country's natural resources, whether it's blood diamonds or gold or the other chemicals, not chemicals, but minerals that are so valuable, and hidden assets from the sale of such pillage in overseas accounts. And that's not the Lubanga case, by the way. But where convicted war criminals have done that, it's not impossible to think some of those funds can be found and clawed back to be used for the victims of that level of greed and abuse. Right now, the trust fund just has a few million euro in it from careful or compassionate countries. But the idea is, with the right defendants, you can get money back. Why do I think that's not impossible? Why do I think that's not just being a Pollyanna? Because nobody after World War II believed that dormant Swiss bank accounts would be found and the money would be returned to Holocaust victims and other victims of what had happened unintentionally at that point in the Swiss banking system, and it has happened. And hundreds of thousands of other accounts were later found and are being resolved by Judge Corman in the Southern District of New York. So that's why I'm optimistic there is a lot still to explore and do here for the new generation, if you're so inclined, of international lawyers. With that, I'm going to thank you for your very good attention and congratulate you again on your transnational law approach.
We've got about 15 minutes for questions and answers. So if some of you have a 1 o'clock class, now's your window. For those of you who are able to stay for another 15 minutes or so, please put up your hand, and if any of you have any questions, I'm confident that we'll be able to continue this extremely interesting, wide-ranging conversation. So,
and don't be shy.
Yeah, don't be shy. Yes?
The question is whether I speak a language other than English, which I also seem to butcher once in a while, and would it be helpful? And I'm asked this question a lot. I speak French, but I have almost never used it in my international law career. It's no longer the second diplomatic language, although it was used at the ICTY. If I were more, and I speak a smattering of some other languages, but in my opinion, the most important languages to learn, from my perspective, international dispute resolution and State Department work are going to be Arabic, Chinese, and Spanish. Professor?
I was just curious to what extent you think the commission format is going to be appropriate for the increasing number of impacts and adaptation kinds of plays for climate change.
I've never thought about that, so I probably shouldn't answer off the cuff, but that never stops me. I suspect that will be done at a government-to-government level and in national courts. Myself, what do you think?
Well, it seems to me that you've got, because of the environmental justice layout of climate change, right, where the major emitters and the major victims don't tend to be the same places, that you set yourself up for conceivably some kind of a compensation format, whether it's more of a government-to-government one than an actual tribunal, especially because you're talking often about masses of people who are going to be impacted in similar ways. We were talking this morning about a tort case that just resolved. There's another tort case that one of the students in here is working on, and she did in class, but working a paper on the Kivalina case where you've got a village that's being inundated, and so sometimes it's at a village level, sometimes it's at a country level, et cetera. But it seems like conceivably variations on it could fit your model. That's what I was curious.
It could. It's an interesting idea. A lot, I predict, will be done in national courts because there are recognized crimes or violations. The other thing I should have mentioned, by the way, is that the U.S. Justice Department has an office, what's it called again? The FCSC, the Foreign Claims Settlement Commission, whose job it is to take lump sums of money from other governments for negotiated violations and then distribute it pro rata to the U.S. claimants. They've got Cuba programs, Egypt programs, and that I could imagine requiring the clout at an intergovernmental level to get a fund of money to then distribute to victims. Certainly needs specialist tribunals. That's a new article. Yes, sir.
If Fernando de Soto is right, there are trillions of dollars lost because of breakdowns in governments and especially in judicial systems. The question, I guess, is given how prevalent autocracies are and how corrupt judiciaries are in many, many parts of the world, are there chances, can you see scenarios to take the claims tribunal approach and go after this kind of predation?
To go after the kleptocracies.
And the corrupt judiciaries?
Well, I'm going to answer indirectly. I don't know if that's the right word. There is a very interesting development in international arbitration right now, which is that the London Court of International Arbitration, which is like the International Chamber of Commerce, not a court, but a secretariat level organization for doing arbitrations between private parties, has been retained to set up an alternative commercial court system in India, which will be staffed by LCIA-appointed judges and have the authority to resolve commercial claims that would otherwise not get, of certain categories that would be hopelessly lost in the Indian system, where there are 500,000 cases pending right now. So that's not really there's a corruption aspect there, but there are some governments that are fed up with their court systems and they're setting up alternative systems based on international arbitration. There is also in Dubai, artificial geographic area that's an international trade zone. There are now 2 international commercial courts that have superseded the jurisdiction of supposedly of the Dubai courts for international commercial disputes. So those things are happening out of frustration. Whether you could get, if you're asking whether I can think of a way to get claw money back from the corrupt judges and the corrupt leaders of the world in order to sort of a Marcos type situation, that would take a good criminal investigation resolve.
Well, in follow-up on that, the cases where countries have set up 2 systems, China with the special economic zones being an example, Dubai also, this represents a path, potentially, to turn predatory systems inside out and to have world standards of justice and rule of law.
Yes.
As Paul Romer suggested, even in partnership, where Singapore could come in
Yes.
to areas and offer contract services or Dubai.
Yes.
It turns out that the value that's created by high trust institutions and rule of law is capitalized directly into the value of land, potentially opening a path for funding the restitution for people who've been preyed upon.
Which is always
by
the
failed
challenge.
systems.
My work hasn't taken me in that direction too far, other than the commercial arbitration avenues. It would be good. Yes, sir.
I was wondering if you could talk a little bit more about the kind of the validity of these vouchers in Bosnia Herzegovina to enforce real estate values. Is that enforced by the government? Because it doesn't seem to me that, like, really the broader question of how these kinds of civil claims are enforced within a country who's still kind of rebuilding itself, and how do you get these vouchers on property that they may own in a different region enforced in a completely separate area?
in that instance, from what I understand from the arbitrators there really hasn't been any enforcement problem there. It's a currency of convenience that individuals take and are using. I'm not aware, I could find out, I'm not aware whether there have been cases where there's been a challenge to ownership with one person claiming that the voucher was invalid. So, enforcement, well, in international arbitration, of course, enforcement is always an issue. In these claims commissions, they only work if there's a pot of money. At the Iran Tribunal, $1 billion was held back when the other Iranian money frozen by President Carter's administration was thawed. The UN Compensation Commission, they had the oil for food, pot. Eritrea, Ethiopia, who knows if they're going to pay those awards. They had asked us to decide just a Delta award, so just say Ethiopia is entitled to $10 million because we'll wash it. We refuse to do that. That's not what our mandate was. Claims Resolution Tribunal, there was money in the bank accounts. It was pre-existing. Now, of course, I should mention, the Swiss banks had, over the past, whatever it is now, 50 years, had paid themselves monthly fees for keeping those accounts open, and secret, often which ate up the total value of the accounts. Part of the settlement with the Volcker Commission, or the deal, was they would reinstate all those funds. So it requires money, and that's why I think it's a real challenge for the ICC trust fund. It's not enough that a few countries throw in a few, even 100 million euros. And then, by the way, this is a very complicated area. There are people who think having victims' trust funds, well, let me start that sentence over. Should the money go to the individuals? Should the money go to the village? Should the money go to clinics for victims of sexual abuse? Should the money go to education to help avoid future generations of child soldiers? The answers to some of those questions are going to bump up against what is the role for international humanitarian relief organizations, what is the proper role for privacy, all sorts of things. Yes, sir.
There's a very deep sense of resentment in the country where I live, which is Jamaica, in the Caribbean, for the slavery which was imposed for 400 or 500 years. It's largely a racial issue because most Jamaicans are black, but and it's held against the European nations which enslaved them. Is there any serious attempt to reconcile the issue?
There's been a lot of discussion, and I must admit I haven't kept up with the literature on that. Maybe other people here have. To the best of my knowledge, so far, the consensus has been that the developed countries consider that's too old a claim and too hard to compensate with money. On the other hand, one could, that's on the one hand. On the other hand, you could say that about the World War II programs as well, the insurance claims and the slave labor claims, the 50 years versus 200 years. There are people writing about it and talking about it. Parallel to that, of course, are the Native American compensation programs as well. Money doesn't solve everything, certainly. It does not. And these, that's an overarching moral issue here on all these claims commissions. Yes?
How big of a role do nationals of the countries you're working with have in determining the funds in the entire process? For example, are there any Ethiopians or Eritreans working on the funds process right now?
Well, we didn't have anybody working except the 5 commissioners, but there were lots of Eritreans on the Eritrean delegation and Ethiopians on the Ethiopian delegation. If your question is whether they had a role in setting up the whole system, they did look through the governments. They did. This was a government-to-government solution. And in the Iran Tribunal, which is ancient history to me, the U.S. corporations and individual nationals had a big role in saying what would, well, let me start that over. most U.S. corporations had already filed in court and had attached Iranian assets, and they were moved out of the U.S. court system to this untested tribunal. There's a Supreme Court case on this, Dames and Moore, saying it might be an unconstitutional taking if there weren't enough money at the end of the day. Yes?
How do these types of sort of tribunals and trust funds and stuff how do they come to be in international? I realize there's sort of different paths. It sounds like Eritrea and Ethiopia actually requested international arbitration. Is that standard, or does it sort of come as sort of an outflux of the criminal prosecution?
Every claims commission has a different story of origin. Eritrea and Ethiopia many people tried to mediate that dispute, including the OAS and finally the UN. And at the end, I don't know, or I can't say whose idea it was on these two remaining issues, the boundary dispute, to use a commission, which is historic in international, very traditional in international law, to have a special ad hoc committee to demarcate, delimit a boundary. The idea of having a commission to resolve Geneva Convention violations, as I say, is unprecedented. Sometimes, to go back to your question, sometimes it's the necessity of avoiding something that in the ideal world just could be done in the national court system, but it's just not developed enough or reliable enough to do it, so one wants international judges. One of the most interesting things, I think, in the current international criminal tribunals is we've gone from the UN, ICTY, Yugoslav Tribunal, Rwanda Tribunal, to mix international and national tribunals in the case of Cambodia and in the case of Sierra Leone, where you've got a amalgam of national judges and international judges, recognizing the importance of the national interests in these criminal tribunals. Yes, sir.
What role does nationality play in determining who gets appointed judges or commissioners to these various tribunals?
Depends on the tribunal. At the Iran U.S. Claims Tribunal, there were 9 judges. 3 were Americans, 3 were Iranian, and 3 were selected by the 2 governments, generally, from non-American, non-Iranian candidates. The UNCC, the UN appointed the judges across a broad geographic scope. I think there was never a single woman commissioners at the UN Compensation Commission, which was interesting. Claims Resolution Tribunal, the Volcker Commission selected, I think, 9 or 12 leading individual arbitrators from many different countries, including the U.S. and Israel and Switzerland and other places who devoted part-time to it. Eritrea, Ethiopia. In the peace agreement, each government was entitled to name 2 arbitrators of any nationality, and the 4 picked the chairperson. I have mixed feelings about the fact that there were 4 American judges on the Eritrea Ethiopia Claims Commission and one Belgian. I would have thought it would be more widely distributed. I thought you were going to ask, how do you make sure that only nationals are claimants in these claims commissions? And there is a jurisdictional test that has to be met. They're very definite. You have to prove your nationality as an American company or as a Palestinian or whatever. They're careful about that. And then you've got dual nationalities and dominant effective nationality, all sorts of international law constructs.
Folks, we're right on the edge. Does anyone else have a question, or are we good? All right, we've got to break. Lucy's got to get back to New York and lunch in between, so let us thank her for